Better Business for Good TV. By small business owners, for small business owners.
Welcome to episode 8 of Better Business for Good TV. I'm Brenda Thomson. My guest today is Harvey Bowlt. Harvey is the principal of Bowlt Commercial Lawyers and an accredited specialist in commercial law. He specialises in proactively helping businesses manage legal risk and has expertise in a number of commercial law areas. But a significant area of his practice involves advising and registering trademarks for clients. So I asked Harvey to tell us what small business owners need to know about trademarking.
Well, a trademark, the IP Australia definition is a word, phrase, letter, number, sound, smell, shape, logo, picture, movement, or aspect of packaging, or a combination of these. Now, that's a bit of a mouthful, but it's very broad, and there's some interesting stuff in there. So, for example, a sound. There is the Happy Little Vegemites jingle is an example of a trademark, a sound trademark. And you might have seen the movement there. The movement, the Toyota person jumping up into the air is an example of a movement trademark. And believe it or not, a smell. And the only one I could dig out was that apparently there's a smell trademark attached to a eucalyptus smell on a golf tee, believe it or not. Anyway, so it's, and they're used to distinguish a company's goods or services from another company's goods or services, and that's what they're for.
So it's not the same thing as a business name or a company name?
No, company, that's a good question actually, because a company name, as the name implies, is obviously just the company name itself. A lot of people have the misconception that a business name, if they have a business name or a company name, then they've got IP protection, and that's not the case. Basically, a business name is just there to enable someone to go behind the business entity and find out who it is. So, for example, if you have ABC Pty Limited trading as Fred's Flowers, Fred's Flowers is not a legal entity. So, if you can then track it and find out who the entity is behind that business name. There's no IP protection there. So you need to register a trademark to get that proper IP protection. And you obviously then have the benefit of the Trademarks Act to back you up if there's an infringement.
So we talked about Vegemite and Toyota and brands like that. Does your average little Jobo business really need to do this?
Yeah, I mean, well, and I often get asked that. Another good question there, Brenda. Yes, if you're wanting to distinguish yourself in the marketplace, you do need to do that because, as I say, there's no IP protection with a business name. And if you have a brand and or a product or both that need protecting, then you should be registering a trademark to distinguish yourself and stop someone else using that name and confusing people in the marketplace.
So there's your business, so there's your brand name. What about individual products? Do they get covered by your brand name, or is this an ongoing, every time you have a new product, you need to do the same thing with the product?
Well, yeah, a lot of people think that if they just have their brand name trademarked, then that's sufficient. But let me give you an example of perhaps let's say a brewery, where, it might be Billy's Brewery. You might trademark that. You might have a whole range of beers that are actually doing rather well. So you should be trademarking each of those beers or products as well. And of course, I love that example because what better way to go and have a couple of boutique beers and then see whether you should be trademarking them as well. Anyway, a bit of fun there.
Oh, Harvey.
Ideal client, perhaps.
So do you have some tips for developing a strong trademark?
Yes, I mean, I think the first thing to do is to make sure that you do your due diligence because, and that's before you go out and set up your brand if you're starting a new business or if you're going to rebrand. Because I've had numerous examples over the years of talking to people who've started or rebranded and then find that someone comes along and says, well, look, actually, we've got something very similar and you shouldn't be using that. And now when you're several $1,000s down the track of rebranding, you've got, you end up with problems of possibly having to change your name. So do your due diligence first, and that means just checking the marketplace and perhaps even Googling and finding out what's going on there. And I'll give you an example. I've had situations where we found out that there might be a small business in Canberra or Sydney or somewhere doing something, and that's very different to suddenly Googling it and finding out that a business has a presence in all of the capital cities in the country. And if there's a small business that's not really maybe even trading, the chances are they haven't registered a trademark and won't be interested if you do. But if it's a big, perhaps a multinational that is trading, then they're going to be very interested if you register a mark that might clash with theirs. So that's the one thing. The other thing is to make sure that you try and get something distinctive. So, for example, some type of hybrid or made-up word would be ideal. And if you don't have something that's hybrid or made-up word, then try and distinguish it some other way. And the obvious way to do that is if you have, say, a couple of fairly generic words, is to have a logo that goes with it, and that makes it more distinctive. Because you see, IP Australia, if you put in a trademark, let's take a simple example of Fred's Flowers, the one I used earlier. If you try and register that, you're not going to get that through because it's very generic. Fred is a very common name. So, but if you had a fancy bunch of flowers or a tree or something with it that was distinct, making it more distinctive, then there's a much better chance of registering that. So if you have something fairly generic, then get a logo to go with it.
Can you talk us through the steps in the process?
Well, very briefly, the application process is a twofold one. You have to get past IP Australia, they have to approve it, and then it's advertised for objections by third parties. And that's done much later in the process. If you get past IP Australia, you basically sort of 95% of the way there, because only between 3 and 5% of trademarks are opposed at a later stage. It's a 7.5-month process, which is to comply with international treaty obligations, but it is backdated to the original date or priority date of your application. And very simply, I always advise clients to do what's a preliminary application called the TM Head Start application. And the advantage of that is that you get an answer within 5 business days from Australia as to whether they provisionally accept it. And if they don't, for whatever reason, and you can't get past that objection, then you can withdraw it without incurring significant costs. And the other advantage is that it's not actually on the IP Australia record. So any potential competitor isn't aware of the fact that you might be bringing the application. So, it saves costs, it saves time, it's designed to be streamlined.
Now, you see little TM and R in a circle symbols. What do they mean?
Well, the TM in some countries is a sign that it is actually formally registered. But in Australia, the TM just means that you either you've got a mark that's unregistered and you're just saying to people, well, look, don't infringe my unregistered trademark, which doesn't actually have much protection, or that you've actually lodged an application and it hasn't been registered yet. But the R can only be used when you've formally registered, the R in a circle. So that's how we do it in Australia. Slightly different in some countries as well.
Okay. And any other tips or traps for the unwary that we could finish up with?
Sure. There are a couple of other things to think about. If you're registering a mark, in some cases, some businesses register it in a separate entity so that if you've got a valuable mark, it's actually quarantined from your trading entity. So if anything goes pear-shaped with your trading entity, your mark is registered in another company and is separate. You can imagine what something like a Google is worth, or Amazon's worth about $220 billion US at the moment. So slightly more than most businesses, but that's how much a trademark can be worth. You can rest assured it's registered separately there. A couple of other things. If you register a mark, you should use it, because there's a so-called use it or lose it principle involved with trademarks. You can lose them if you don't use them within a 3-year period. And that's probably about it. If you ever get a nasty thing called a cease and desist letter, which it could be from lawyers acting for someone else saying you're infringing their trademark, they are scary, but don't panic. get proper advice and see what you can do about negotiating some sort of settlement in relation to your mark. It's not the end of the world if you get one. I've had a few clients who have, and they are rather scary.
This interview was an excerpt from Better Business for Good TV, episode 8. You can watch the full show at bb4g.tv.
Better Business for Good TV. By small business owners, for small business owners.